All right, we're on a little bit of a break here from that hearing. As a matter of fact, there's a briefing schedule. It will resume sometime in the future, in November, it sounds like. Let me introduce my guest. You know him well. Rich Schoenstein is here with me in the studio. And of course, my Wednesday guest, Neil Rockind, both great criminal defense, both great trial lawyers. Neil, let me start with you. First of all, give us a little format of what a suppression hearing versus a Franks or including a Franks is. But the one question I want to know is, could the defendant, Willard Chaden, as he goes by his middle name, Miller, a juvenile being tried in adult, could he have taken the stand here?
Great to be here, Linda. Great to see Showtime over there. The fact is, a suppression hearing is where a defendant files a motion to have evidence excluded, typically on a basis that the police or the prosecutors have violated his constitutional rights. In this case, we see two different types of suppression issues that the defense lawyer is arguing. One relates to Miranda and a confession, and the other relates to Franks. Franks is really just on the paper. It begins with an analysis of whether or not the state obtained a search warrant, or the police obtained a search warrant, and that search warrant was based on lies and statements that were demonstrably false or made with reckless disregard for the truth. The judge is going to review the pleadings and review the affidavit and make a decision whether or not, one, there's evidence that there were untruths in the affidavit, and the second is whether or not, if you strike out those untruths, is there probable cause remaining? And if so, then there would actually be a hearing where witnesses could testify. At a suppression hearing on Miranda or the voluntariness of a statement, yes, a defendant can take the stand and testify. He'd be exposed to cross-examination by the prosecutor, and he can testify as long as he explains at the beginning that he objects to his testimony being used for substantive purposes. Then it can only be used for the purposes of that hearing. There are many dangers, which I'm sure you're aware of, if a defendant testifies at a suppression hearing. Those typically relate to impeachment, and the prosecutor can begin to talk about things related to the case, like motive, intelligence, and intention to lie.
Okay, so both of you, this brings me to the final question that you know was coming, and is at the end, because I assume that the interview went beyond about 7:30 a.m. time. The mother called her friend, a police detective in Oregon. The police detective spoke to the detective here and said, "Shut it down." In other words, we're withdrawing consent. And apparently, I gather the interview continued. Can that interview continue at that point? No, Neil, let me just call you Rockweiler, as you're known.
It all depends on Iowa law, but in Michigan, for example, and many of the states that of which the law I'm familiar, the answer is no. The evidence, the interrogation can continue. It doesn't matter whether a person is being accused as an adult. That's a formality that applies in court when someone is actually charged with a crime. But you're still, when you're interviewed and under investigation, you are still a juvenile, and you're still entitled to the same protections and rights as juveniles. Each state may have different laws, but if his mother insisted on being there or was misled, and so she wasn't able to be in the room, but they were able to shut it down, and the police continued, I think that's a problem for the state. The evidence could be excluded past that.
Neil Rockind, I know I have to say goodbye to you because we're coming up to a hard break. But your thoughts about this case? This defendant, he actually killed, according to the state, Guillermo Arriola. Supposedly, when this sheriff's officer arrives at the scene, he refused to give his name, even though that he was called to the scene by him or his father. Talk to me.
I think self-defense cases are always interesting. There are a lot of twists and turns, because the state really has an additional burden whenever anybody's arguing self-defense. Without going too detailed, it really makes a lot of sense. Self-defense essentially is that if you acted honestly and reasonably at the time, even if you were wrong about what you thought you saw or heard, even if you were wrong about the amount of danger you were in, or whether you were actually in that degree of danger, as long as you honestly believed it, as long as your belief was reasonable, you can defend yourself. And it's going to be interesting to see how it plays out.
And I hope that you'll be back with me next week to talk about it. All of you stay with me. We're going to thank you, Neil Rockind. We're going to take a quick break here. When we come back, Cummings and also Cruz, stay with us here on the Law and Crime Network.